Counsel, you all ready? Okay, wait a second. The next case is Sedgwick Claims Management Service and the Geo Group versus Ryan Thompson. It's case number 230193. Ms. Klein, you may proceed when ready.
Thank you, Your Honor. Hinda Klein and Unia D'Amico Nadler for the employer carrier in this case. I would like to reserve 5 minutes for rebuttal. Essentially, the facts of this case are very, very simple. Mr. Thompson was working for a correctional facility. He was transferred to a position where he drove around the perimeter of the facility all day for about 8 hours a day. He did take breaks. He drove very slowly. He was in that position for about 2 months when he claimed all of a sudden that he had neck and shoulder issues. He initially went to MD Now, at which time he told them that his neck pain had just begun.
I'm going to jump right into what I think is a really critical issue, an interesting issue, matter of first impression here, and that is, does Section 440.25, which states the EMA opinion or testimony shall come into evidence, and how that interplays with a Daubert objection, is if Daubert is an admissibility gatekeeping mechanism, how does that mesh with the clear statutory directive that EMA opinions shall go into evidence? So do we have a statement by our legislature, whether we embrace it or not, that Daubert does not apply to EMA opinions?
Well, I think this court has already answered that in the Juneau opinion.
See, I don't think that that issue was addressed in Juneau. There was no argument with respect to what the interplay or what the effect of 440.25 was.
Well, the specific interplay, I guess, was not raised in that case. I would agree with that, and I know opposing counsel has relied on a concurring opinion basically to raise that issue in this case. However, I think that while the legislature used the term shall, it could not have actually meant, no matter what the EMA opinion was, it must be admitted into evidence.
So that, unfortunately, sounds like a policy argument. Perhaps it wasn't a wise statutory mandate, but so many times we struggle with statutory interpretation questions because the statute is vague or it's ambiguous. That is not the case here. It could not be more clear that the EMA opinion shall be admitted into evidence. What do we do with that, or what's your best argument that we should not apply that language as it's clearly written and instead apply a more general evidence code provision?
Well, I think our best argument in this particular case is that our second point on appeal is that the JCC should not have considered the EMA opinion as dispositive.
Can we focus, though, a little bit more on the first argument? And again, you're incredibly experienced as your co-counsel, and this is an interesting issue for us. What do you make of the tension between this very specific statutory provision in the workers' comp law with the more general evidence code provisions?
I mean, there's clearly a conflict there. There's no question. However, Daubert is, as the court has noted, an issue for the JCC as the gatekeeper. So I believe that under the circumstances, the Daubert 90.702 should basically trump the workers' compensation statute.
So is your argument that when the legislature adopted Daubert and the evidence code that they largely repealed 440.25 sub 4 by implication?
No, I'm absolutely not making that argument.
So I'm trying to, because repeal by implication is disfavored, and courts usually don't do that. And so I'm trying to figure out how we rationalize these two statutes that seem to be in conflict. And Judge Ray alluded to the fact that generally if we have a specific statute takes precedence over a more general statute. Certainly the evidence code applies generally to evidence, but we have a specific statute in the workers' compensation law that says
It shall be.
EMAs shall be admitted into evidence. So I'm wrestling with this, so help us.
Well, I think my best response to that is that even if there is this conflict, then I would rely on my second point, which is that the court was in error, JCC was in error in giving it, frankly, any weight in this circumstance. The arguments against admissibility are the same arguments we would raise with respect to the JCC.
So for the most part, when we have the JCC or a circuit judge or any trier of fact or a jury in a jury trial, the relative weight to give to a piece of evidence is totally within their purview. So how do we wrestle with that?
Well, while the weight is within the purview, that assumes that there is some weight to be given. If the EMA, as is the case here, basically didn't give an opinion, then it deserves no weight. The JCC in this case found specifically that the opinion was not equivocal or inconclusive, when in fact the opinion was absolutely both. In fact, the EMA virtually refused to give an opinion on the specific issue that was before it, which is where there is a pre-existing condition or evidence of a pre-existing condition. Is there evidence of sufficient repetitive trauma to conclude that the repetitive trauma was the major contributing cause of the claimant's condition? In this case, I've never seen an expert testify like he did. His ultimate conclusion was, it's not my job to give this opinion. It's your job, EC, to prove me wrong. And since he began having the symptoms during his work, that's all I need to say. He had these symptoms for the first time at work, and it's your job, employer carrier, to give me, the EMA, clear and convincing evidence that there was an alternative cause. And under the circumstances, this EMA's opinion was frankly not worth the paper it was written on, and it should not have been given any shrift by the JCC.
I find that in looking at the JCC's opinion that perhaps that's apparent from the final order, because he does go on and analyze specifically the other IME testimony and what they had to say. It wasn't just strict reliance on EMA. So could you address that point?
Sure. There were 3 other physicians who testified. Dr. Bridges, who was the treating physician, who testified that initially he thought that there was some kind of accident that the claimant had suffered. But when he discovered that that was not the case, he said absolutely this disc herniation was not work-related. It was not repetitive trauma-related. Dr. Schechter, the employer carrier's IME, testified that driving around the perimeter of the property could not have caused the disc herniation. It was caused by degenerative changes of long-standing nature, and it would take a great deal more than the 2 months he was.
But it wasn't the driving; it was the constant having to scan to see if the wire had been breached or someone was running across the yard or something like that.
That's true, but the claimant testified it's because I was looking right and left, and that's not something that anyone was able to establish. Is not something that occurs in the course of everyday activities. Dr. Rausch, he did testify, and this is why the EMA was appointed in the first place, that the claimant's condition was caused by repetitive trauma at work, but as we pointed out, he did not consider anything that the claimant had done outside of work. For example, that how often do you drive, how long do you drive, do you look right, do you look left, anything like that. He simply just said, well, he's looking right and left at work, and therefore I believe it was a work-related injury. Then Dr. Cameron comes along. He answers the MCC question in the affirmative, but he too didn't know how long Mr. Thompson had worked in his position, didn't know his driving speed, how many miles a day he drove, how much time he spent in his own vehicle. He knew nothing about whether or not Mr. Thompson ever turned his neck when he was outside of the work.
I see we're getting short on time. If I can ask you one question. What relief are you requesting? If we accept your position, what relief? In the initial brief, it says reverse. In the reply brief, it's more specific, reverse and remand.
Reverse and remand is what I believe is appropriate under this court's case law when the JCC makes an error with respect to accepting the EMA's opinion.
So back for a new hearing.
Back for a new hearing with the JCC reviewing the EMA's opinion under the correct test for determining whether or not there has been an opinion rendered regarding the trauma, the repetitive trauma theory, which was the theory that the claimant proceeded on. I will reserve the rest of my time for rebuttal. Thank you.
Good afternoon. May it please the court. Ken Schwartz on behalf of Mr. Thompson, the appellee. I'm going to dive right in on the statements made by my opposition because I think there's something that needs to be clarified immediately. The argument essentially is that they don't like the opinion of Dr. Cameron, the EMA. I think that's what it all boils down to in the end. And one of the last allegations that was made is that Dr. Cameron didn't have sufficient knowledge of the circumstances to be able to offer an opinion that should be considered competent substantial evidence for the court. I would submit that that's absolutely false, and I think it's verifiable by the actual testimony of the doctor and the evidence. So Dr. Cameron, in his report, on the first page, recites what he reviewed in preparation for giving his opinion in answer to the JCC's question. In the list of items that he reviewed are medical records from doctors, the deposition testimony from...
Well, maybe I misunderstood her argument, but I thought her argument was not really that Dr. Cameron didn't review the records, that Dr. Cameron didn't really provide a substantive opinion in any way.
Well, she said two things. She said that, but she also said that he didn't have sufficient information about what the claimant was doing to offer an informed opinion. And the reason I'm reciting these records is to demonstrate that that's not true. If you look at page 1 of his EMA report on page 142 of the record, he clearly indicates that he had the affidavit of Scott Johnson, which was the supervisor of the claimant, and he had all these deposition transcripts. In all these transcripts, the circumstances of his work, including the fact that the claimant had been working for approximately 2 months, is patently clear. If you look at the affidavit of the supervisor, not only does it give that summary, but it gives the specific shifts he worked on, the specific days and the specific number of hours each day that he worked. He specifically indicated the number of miles that the claimant worked or drove around the facility on each of these days. And Dr. Cameron reviewed not only that affidavit, but he also reviewed the video that was prepared by the employer carrier that evidenced what the claimant's job duties were on any particular day. It wasn't a video of the claimant himself, but it was a recreation showing how he would look side to side and over his shoulder, looking for potential escapees or other people who might be on this prison facility. So to suggest that Dr. Cameron didn't have enough information about the claimant's work duties is not supported by the record in any way. So I want to clarify that right away. As for his opinions not being worth the paper they're written on, I again respectfully disagree with that because Dr. Cameron made clear that he reviewed a substantial amount of information. He spent 2 days both before and after the physical examination that he performed. He went through MD Now records, he went through Concentra records, the depositions from the IMEs, So he had enough information from the history as well as from his own interactions with the claimant to make an informed decision about why he felt that the major contributing cause of the need for care and was the claimant's work
What else did
responsibility.
he consider, though, other than the fact that the injury occurred at work?
What else did he
Yes,
consider?
what else did he consider?
Well, the totality of the circumstances, and it's difficult to consider something that doesn't exist. He talked to the claimant about his history, and there were no pre-existing conditions that were identifiable. There was some degenerative changes noted on the MRI report, but they were asymptomatic. There was nothing about those that required any sort of treatment either before or after the accident, independent of just appearing on an MRI. So these are not things that can be considered causes for purposes of a major contributing cause assessment. It was just a statement of how the body of the patient presented when it was in the MRI coil that day.
Well, even if we accept your argument and accept and embrace Dr. Cameron's opinions, etc., is that enough to satisfy the MCC provision of the statute that you're arising out of, other than the fact that he had pain when he was at work?
Well, I don't think that testimony supports the premise that it was just that he had pain while he happened to be on the premises of his job. He testified that the incident that he was doing his normal job duties when he first experienced pain in
Right,
December.
but didn't all three IMEs acquiesce at some point or the other? He could have been driving home and had this neck pain. He could have sneezed and had this same type injury. What specifically was there to pinpoint the work-related activity as the cause?
Dr. Cameron said that the presentation was fairly simple. And this is actually cited, this page in the transcript is actually cited by both sides in support of our respective positions. So I'm going to make sure I get Dr. Cameron's reports correct. So the question put to him on page 349, after some discussion of him saying that there was some cellular pathology at issue, was the presentation was consistent with what? A repetitive injury? And the answer from the doctor was, if the answer you're looking for, repetitive use has led to cellular inflammation and disc herniation at a mechanical level, yes. The answer is yes. So Dr. Cameron clearly contemplated that there was more going on than just the claimant had some pain while he was on the job. He testified that it was the claimant's repeated driving in this particular vehicle that, as the claimant described from the very beginning, was in some state of disrepair that wasn't adequate and not the same as his ordinary vehicle or the usual vehicle you would find on the road because of its state of disrepair. He was looking this way and that way and over both shoulders, looking for other people. So this wasn't just the same as he's on the turnpike or he's around his neighborhood and this same exact thing could have happened. It was work-related, it was an imported risk of the employment.
So do you concede that there was a pre-existing condition? I wasn't sure about your testimony when there was or was not a pre-existing condition.
Well, it depends if you're using that as a term of art to have some significance.
Okay, a
Yes, there was.
pre-existing condition in terms of causation.
Not in terms
Shifting
of-
burdens of proof, was there a pre-existing condition that dictates shifting burdens of proof or not?
I don't believe so. I think that there was some degenerative findings. I don't think that's in dispute. But the question is, for purposes of major contributing cause, did they independently require any treatment before or after the accident? And the answer is no, they didn't. These just happened to show up on an MRI because, as Dr. Cameron explained, once you stop growing, you start essentially degrading. Everybody is going to have some degeneration once you stop growing in life. And that's the case with this gentleman as well. It wasn't a causative factor in this case, and he dismissed it as being relevant to the determination of the work-related nature of the injuries. So I also wanted to address the other part of your question, which is the sneeze. That was a throwaway comment by the doctor. That's evident from the transcript. He was saying, well, it could have happened while he sneezed. He might as well have said it could have happened while he was playing football in his backyard. They had the same significance to the testimony. He was saying that, sure, other things can cause injuries to the neck because the neck is a load-bearing structure and it's not all that sturdy. So things can happen that can cause injuries, and one of them could be as simple as a sneeze, or it's unexpected, or it's potentially disconnected from work as a sneeze. But importantly, when he was saying, you've shown me no other evidence that something caused this besides what I believe to be the repetitive trauma here, there is no evidence.
You're
of
going
this.
back to the Broadview and Walker line of cases where, if you're at work and an accident happens, then it's compensable unless.
No, ma'am, I'm not. I'm suggesting that Dr. Cameron testified that there was no evidence that anything else happened. So therefore, the repetitive nature of the work that he was doing that made Dr. Cameron believe that the claimant suffered some cellular inflammation and other issues that led to a herniation and the need for surgery were the cause. So there was work that could have been a cause, and that's it. It was a set of one versus a set of nothing. So he obviously picked the one. It wasn't, well, there's nothing that I can find, and therefore you were at work, so I must say it was work. He actually made the connection between the work responsibilities and the injury. He said the presentation was clear, the presentation was simple, and as I read from the transcript, he related the two and said that the major contributing cause was the work, not simply he was at work, and therefore it's the cause. So as far as Dr. Cameron and the sufficiency of his testimony, I think that's really point 2 of the appellant's arguments. They're saying that Dr. Cameron's opinion should not be afforded any sort of presumption of correctness, let alone any sort of believability. They said, not worth the paper it's written on, I believe were the words. Well, I don't know that we even get that far because, as Judge Thomas, you raised the question earlier on, does Daubert even apply? Do we even get to that point where the employer carrier had argued that Daubert kicks Dr. Cameron out completely? They tried to do that with Dr. Rausch, the IME. They tried to say that Dr. Rausch, his opinions were not sufficient to support a Daubert analysis. Judge Lewis disagreed and overruled that. It was not part of the appeal. So we have a dispute. We have an EMA properly appointed, and we have an EMA that comes to the table with a presumption of correctness. And the employer carrier is trying to argue that the Daubert test should not let us even get to the presumption of correctness because there's some sort of reliability issue that he has that keeps the judge from applying this presumption even though it's statutory and mandatory. And as framed in the brief, I don't think that Daubert applies to the EMA because we have this clear language in 440.24d that the report or testimony of the EMA shall be admitted into evidence. Full stop. There's no qualification, there's no equivocation. It's not like 440.29 sub 4 where the records, not records and testimony, but the records of the authorized treating physician shall be admitted into evidence upon proper motion. There's an equivocation in there, there's a threshold. You have to have the motion submitted to the JCC, which puts the other side on notice that you plan to introduce certain documents that you have to circulate more than 30 days in advance of the final hearing so that the other side is given warning of what you intend to have in the record.
Let me ask you this. What's the standard of review for the JCC's acceptance of the EMA? What's the standard of review for us?
Well, at trial it was clear and convincing, but now that we're up on appeal, the question is there CSE in the record? Is there competence substantial in the record to support the JCC's statement that there was clear and convincing evidence for him to decide that the major...
I would argue that it may be higher abuse of discretion, but you were on, the Christian case is very interesting to me, and I think it's quite applicable, and I think you were on that case.
Yes.
Judge Jay, in that opinion, made the statement, the judge did not abuse his discretion as a matter of law. Do you think it's a combined de novo and abuse of discretion standard in these circumstances?
I don't think it's a question of statutory interpretation, so I don't think that it escalates up to a de novo. As far as abuse of discretion, I would say that if you're talking about if the judge had decided that he was going to reject the opinion, then I would definitely say that it's an abuse of discretion. But at this point, I think that it goes the other way. He didn't grant the motion that the employer carrier brought to try to strike Dr. Cameron. He denied that motion. So now we get to the final opinion. So it's not a question of admissibility of the evidence. It goes to the conclusion because there was admissible evidence. And at that point, I think that it becomes a CSE question.
So are you aware of any case, I certainly couldn't find one that hits this issue head on, that is, whether there's any Daubert gatekeeping role or try back in the day for the JCC to play with respect to EMA testimony?
Well, it gets kind of complicated because if you turn the clock back to look for cases, you might wind up back at U.S. Sugar Corp versus Henson, which is 2002 from the Florida Supreme Court. And at the time, the standard was Fry. We weren't a Daubert state yet. We were dealing with Fry. But Fry isn't quite the same test as Daubert, and the statute that we're dealing with was also different. The
It
EMA
was different
statute.
because that didn't apply to testimony, and that
Sorry?
so in the Henson case, it was only reports. It didn't deal with testimony. Judge Lewis's opinion, Justice Lewis's opinion, correct?
Yes, that's another distinction. So in 2003, the EMA statute was amended. So it used to be that the opinions or testimony of the EMA shall be admitted, excuse me, strike that, that's the difference that I want to highlight. It shall be made a part of the record, was the way the statute used to be worded. And it said that the EMA's report or testimony shall be given the same consideration by the JCC as is accorded all other evidence submitted into evidence. Now there's importance in those words. Submitted into evidence and made a part of the record are not the same as admitted into evidence. A proffer becomes part of the record, but a proffer is inherently inadmissible evidence. So submitted into evidence and made a part of the record, different. In 2003, the statute was changed to its current version where it says that the report or testimony of the EMA shall be admitted into evidence. No equivocation, not part of the record, not subject to 90.702, admitted, period. That's it. That ends the inquiry as far as I'm
And that
concerned.
cuts both ways. For this case, it may work in the claimant's favor. In the next case, it may work in the employer carrier's favor, correct?
I don't disagree with that. But in this particular instance, I think it's dispositive because the judge of compensation claims admitted, almost out of time, the judge of compensation claims ruled against the employer carrier on the issue of whether Dr. Cameron's testimony should be excluded based on Daubert. Once it was admitted into evidence, there was the presumption of correctness afforded by the statute that can only be overcome by the employer carrier putting on clear and convincing evidence that the doctor's opinions were incorrect. There's no argument here, let alone any evidence of it, that there was that there was clear and convincing evidence against Dr. Cameron. What they're really saying is there wasn't enough evidence from Dr. Cameron to support the conclusion that the judge reached. So although I disagree with that, I think the evidence is clear. There was no clear and convincing evidence put on by the employer carrier to overcome the presumption of correctness. So even if we get past the Daubert admitted into evidence threshold, I think the evidence is clear, and I think Judge Lewis did an excellent job outlining all of the evidence, including both Dr. Cameron and Dr. Rausch. So in a final comment, I'll just observe that even if you accept the employer carrier's argument that if you're somehow able to discount Dr. Cameron as the EMA and his presumption of correctness, what the judge said is, I accept the opinions of Dr. Rausch, and I accept the opinions of Dr. Cameron. So even if there's no Dr. Cameron, you still have the judge accepting the opinions of Dr. Rausch, saying that he believed the major contributing cause of the accident was the claimant's work. And if you accept that if the judge accepts Dr. Rausch's opinions, then there's no need for remand because this court can certainly make a determination on the record that the major contributing cause was work. So with that, the claimant respectfully submits that the case should be affirmed on appeal.
Thank you, Mr. Schwartz.
Thank you.
First, I'd like to clarify something. Our argument is not that Dr. Cameron didn't review the evidence in the record. Our argument is that he didn't consider what the claimant's situation was outside of the work. And that is as important as what the claimant was doing when he first began feeling some pain. This court has a long history of dealing with these kind of cases. The Bison case, and these are all cases in which there were no there was no pre-existing pain, but there was a pre-existing condition, as was the case here. The Bison case was a case where the claimant had a neck pain when he was reaching for his desk drawer. Acker, the claimant began having pain when he was looking up. Brennan, the claimant was putting on his underwear. He was a firefighter. Silverberg, the claimant had a numb leg after standing up after he had been sitting. These are all situations just like this one, where there had been, where there was a pre-existing condition, but it had been asymptomatic until the claimant happened to be at work. Dr. Cameron repeatedly said, listen, this could have happened anytime. It could have happened when he's going to Publix. It could have happened when he was sneezing, when he was walking his dog, all kinds of different things. He repeatedly over and over said that. But ultimately, he said, that's not for me to make a decision on. That is for the employer carrier to prove. But that was not our burden of proof. That is the claimant's burden of proof when you have a pre-existing condition and are relying on repetitive trauma to make a work-related claim. That was not done here, and throughout Dr. Cameron's testimony, he repeatedly refused to answer the very specific questions that needed to be answered given the fact that this was a pre-existing condition where the claimant was claiming that there was repetitive trauma. Page 349 and 356, even if he sneezed on the job, that would have been sufficient according to Dr. Cameron. But he then testified he didn't want to get bogged down into whether the condition had been caused by repetitive trauma. Well, that is exactly what he was assigned to get bogged down to do. He also testified he didn't know if the injury resulted from repetitive use. That's on page 349. Pages 352, 373. Numerous things could have caused the herniation, including sneezing, driving to work, sleeping on his shoulder, driving to pick up groceries, walking his dog, working out. And then he testified on page 374, or it could have pre-existed and become symptomatic at work. But, he testified, that was the burden of the employer carrier. This is the thrust of precisely why Dr. Cameron's opinion should not have been given any weight by the JCC, assuming that it was properly admitted into evidence. He simply did not respond and answer the very specific question about the major contributing cause of this incident. He actually acted as an attorney, and he unilaterally decided what was relevant and what wasn't. And his opinion of what the law is should not have been the basis for his opinion, and that's something that this court can consider on a de novo basis. It is not within the court's discretion to accept an EMA's opinion that is simply not responsive to the specific issue, and which is frankly equivocal and inconclusive, which the EMA's opinion in this case was. And that is really the thrust of our argument, that this case has to be reversed and remanded to the JCC for consideration of the evidence other than the EMA's opinion in this case.
Thank you, Ms. Fine.
Thank you.
I want to thank all the attorneys that appeared today. And having an appellate argument is nerve-wracking enough without being in a room with 400 of your closest friends. So please give them all a hand.